Months after I sentenced her, I got a letter from the director of East Harbor Community Pantry. One sentence stayed with me. She never signs out when the clock says she can. She signs out when the floor is clean. He was writing about a 19-year-old who had once looked up at me from the defense table and told me to get lost. I want to tell you how we got there. When Lila Mercer's case first reached my desk, the papers suggested something simple. 19 years old. No prior record. Daughter of Graham Mercer, a real estate man with enough money to make most rooms lean his way before he ever entered them. The charges were simple assault, reckless endangerment, and property damage. The injury report was not simple. Neither was the victim statement. I knew before I ever saw her in person that there was a range in this case, and I was going to be responsible for where inside that range I landed. I want you to subscribe before I keep going. Not because what I am about to tell you is dramatic, because it is the opposite of dramatic, and those are the stories that need the most people to hear them. Subscribe and turn on notifications. Then let me continue. People who have never sat where I sat sometimes imagine sentencing as a switch. Guilty means one thing, not guilty means another, but most sentencings are not like that. The law gives me boundaries. Inside those boundaries, I still have to decide what kind of answer fits the truth in front of me. In this case, I chose the lowest end of what the law allowed. I want to tell you everything I saw that made that the right call, because it was not obvious from the outside, and it should have been. Before the hearing, I had probation prepare a young adult review packet. That is one of the tools I value most when the defendant is very young, and the facts suggest there may still be time to build structure instead of only imposing pain. In plain language, it means I can ask for more than the charge sheet. I can ask who this person is on a normal morning, what they do when nobody is trying to win a case for them, and whether remorse has taken root anywhere outside a courtroom. The first time Lila Mercer stood in front of me, she wore a dark blue coat and shoes that had never seen bad weather. What caught my eye was not the coat. It was her left hand. She kept turning a silver ring around and around until the finger beneath it went red. Then she would stop, press her palm flat against the table, and make herself still. When the clerk asked her to speak up, she said, "Sorry," before she answered. Quietly. That told me more than people realize. I was looking at someone raised to resist control, but not someone beyond reach. The victim was Rosa Delgado, 52 years old, operations manager at East Harbor Community Pantry on Bergen Street. She came in with two fingers taped together under a soft brace and a folder of invoices held tight against her side. She did not look at Lila when she entered. She looked at the witness stand, then at the rail, then at the clock. She wanted the hearing to begin. She wanted the truth stated cleanly. When I later asked what she wanted me to consider at sentencing, she said, "I need my hand to heal, Judge. I do not need her ruined. I need her useful." There was also a boy in the second row most people were not watching. He was maybe 12, with a school tie still on and shoulders that looked tired for someone that age. He was Lila's younger brother, Owen. Each time their father leaned toward counsel to speak in a low, sharp voice, the boy looked down at his shoes. Each time Owen did that, Lila stopped turning the ring. She would sit straighter and look once toward him, without moving her head much. I noticed that before I heard a word of testimony. It stayed with me. Subscribe before I keep going. I made a choice in this case that I want to explain fully. Subscribe now. Because the reason I made it is coming, and I want you to be here for the whole explanation. The incident took place on Saturday, October 18, 2025, at 7:46 p.m. in the rear loading lot of East Harbor Community Pantry, 214 Bergen Street, Newark. Graham Mercer had arranged a donor photo event there. The pantry had a late produce truck arriving at nearly the same time. Those are two different kinds of evenings. One is built for appearance, the other is built for work. They were forced into the same space, and then a 19-year-old with a short temper and too much practiced escape tried to leave before the room around her was ready to let her. 3 witnesses testified that Lila had argued with her father near the side entrance before she ever reached the car. One heard him tell her she would stay until the photographs were finished. Another heard her say she was leaving. Rosa Delgado testified that the white Range Rover was parked partly across the marked unloading lane, and she approached the driver's side to tell Lila to wait 3 minutes until the truck cleared the ramp. Lila said, "Then get out of the way." She put the vehicle in reverse too soon, cut the wheel, struck a rolling produce rack, and sent crates across wet concrete. When Rosa reached toward the door and said, "Stop," the door swung back and crushed Rosa's right hand against the frame. The damage spread farther than the first point of contact. Rosa suffered 2 fractured fingers and bruising across the knuckles that required 8 weeks of therapy. East Harbor lost a rack, a load of dairy, greens, and several hours of orderly distribution on a night when families were already waiting. The invoices were precise, so were the medical films. I did not have to guess whether real harm had been done. It had. 3 days later, at her first appearance, I asked Lila whether she understood the charges and the conditions of release. Her father's lawyer started answering for her. I stopped him. I said I wanted to hear from her directly. She looked up at me with anger that was trying very hard to pass as control and said, "If that's how this works, then you can get lost." The room went still, then her expression changed. She knew the moment the words landed. I watched regret arrive in real time. I could have held her in contempt on the spot. I did not because the outburst did not matter. It did. A courtroom cannot keep its shape if no one respects it. But discretion means more than power. It means deciding which response serves the truth of the case and which one only satisfies the room. I told her that if she wanted to be heard as an adult, she would speak to me like one from that point forward. Then I moved on. I chose not to turn 5 ugly seconds into the whole story. From the bench, entrances tell me things no transcript ever will. At the evidentiary hearing, Lila came in walking too fast, shoulders high, chin set, until a court officer crossed in front of her and she slowed for half a step to let him pass. That half step was not for show. Rosa entered differently. She carried her folder under her left arm because her right hand still did not close fully. She rested that injured hand against the rail for a moment before sitting down, as if she was checking whether it could bear weight. Both women were telling the truth before either of them spoke. The first turn came from a sentence that was not legally important on its own, but changed how I read everything after it. Malik Price, a 19-year-old volunteer at the pantry, testified about the crash, the scattered milk crates, and Rosa falling to one knee. Then the prosecutor asked what Lila did next. Malik said, "She did not run. She knelt and spilled milk in those expensive shoes and held Ms. Delgado's wrist above her heart until we got ice." I remember the exact way he said it, no flourish, just fact. The case stopped being flat in that moment. I went back through the scene photographs after that testimony, not the damaged shots, the wider ones. In one of them, at the far edge of the frame, there she was on the ground beside Rosa with her coat sleeves dark from wet concrete, one hand under Rosa's arm, the other pressing a towel over the swelling. Nobody had highlighted that for my benefit. It was just there, waiting to be noticed. That matters to me. I have seen many people careless enough to cause harm. I have seen fewer stay fully present to the sight of what they caused. There was another sentence in the probation packet that told me something true about her circumstances. Lila said, "At my house, if something ugly happens, somebody pays it and nobody says it again." She said it without self-pity, just plain. That did not excuse the injury. It did explain something about the air she had been breathing for years. Accountability sounded unnatural to her because avoidance had been taught to her as normal. Subscribe before I continue. I have been building to something in this story, and it is not where you might think it is going. Subscribe and let me get there. The second turn came in a stack of ordinary papers. Timesheets from East Harbor Community Pantry, signed in blue ink by the shift supervisor, Jerome Beck. December 13th, December 20th, January 3rd, January 10th, then more. 6 in the morning loading shifts, evening cleanup, inventory counts, no cameras, no donors, no public statement. While I held sentencing open, I had allowed an interim work arrangement with the pantry under probation supervision. Those papers showed me not emotion, but pattern. Pattern matters. She was early on 9 of 12 shifts. She completed a food safety course without being ordered to do it. She covered one absent volunteer on January 24th. She logged 42 hours before the defense ever asked me for leniency. That sequence mattered to me very much. People can perform remorse when they know a sentence is close. It is harder to perform cold storage work at 6 in the morning in January when the floor is slick, the boxes are heavy, and nobody present cares who your father is. When those records came into evidence, I looked around the room. Rosa stopped rubbing the brace on her hand and set both palms flat on the table. Owen leaned forward so far the family driver beside him had to touch his sleeve and pull him back. Graham Mercer, who had been tapping a black pen through most of the hearing, put the pen down and did not pick it up again. I do not build rulings out of gestures, but I watch them. They tell me when truth lands. The defense was asking for something I was already considering, though not for the reason rich families usually hope. Lila's lawyer, Elena Keating, did not try to shrink what happened. That helped her. She said, "Judge, my client was reckless, disrespectful, and used to being protected from the natural cost of her choices." Then she said something better than most defense arguments I hear. She said, "If you spare her jail, please do not spare her structure." I appreciated that because it was honest. She understood that kindness without shape would fail this young woman. The defense got one thing wrong, too. For a moment, Ms. Keating tried to wave away Lila's words to me as youthful stupidity. They were not. They were contempt. Fear may have been under them. Pride certainly was. I was not going to let that part vanish simply because I could see where it came from. Mercy that lies about conduct is not mercy. It is avoidance in better clothing. When Lila testified, she was not polished. Good. I trust plain speech more. She said, "I heard her because I was angry and because I thought being angry gave me permission to move. It didn't." A little later she said, "I kept thinking if I got out of there fast enough I would not have to feel small." Then she looked straight ahead, not at her father, and said, "Don't let him pay this away. Make me do it." That was the moment I knew what I was going to do. I wrote it down, not because I needed to remember it, because I wanted to. Subscribe. I am not going to make a speech about it. You are already in this story. Subscribe and let me finish. There was a memory this case brought back that I had not visited in years. I was 14 years old in February of 1989, standing in the basement of St. Luke's with my mother. Snow had melted into the cuffs of her coat. The room smelled like wet cardboard and coffee. A man in a green apron slid a paper bag across a folding table to her with rice, beans, canned peaches, and peanut butter inside. Then he said, "Take 2 loaves. We have enough today." He looked her in the face when he said it. That is all. I never explained that memory to anyone in court. It sat beside this case anyway. By March 20th, 2026, I had everything I needed. The offense conduct was clear. The injury was real. The outburst in my courtroom was real. So was the work that followed. The probation report showed she had enrolled in 9 credits at Essex County Community College and paid the first bill from an account in her own name. Rosa had submitted a short note that said, "She has started learning people's names before she tries to apologize again." That is one of the better sentences I have read in a case file. I have not told you the full sentence yet. I am about to. Subscribe before I do, because I want to explain every part of it, and the explanation is as important as the ruling itself. Subscribe now. Before I spoke, the room had a very specific kind of attention in it, not fear, not relief. The attention of people waiting to find out whether a court is about to use all the facts it has or only the easiest ones. Lila stood very straight, but her thumb had found that silver ring again. Rosa had both hands folded over her tote bag. Owen was in the second row with his chin up this time. I had made the decision carefully. I had made it knowing that mercy, to mean anything, has to be precise. Vague mercy is just hope. Precise mercy is a plan. I had a plan. I found Lila Mercer guilty on the admitted facts of simple assault, reckless endangerment, and property damage. Then I gave sentence. I said, I am ordering you to pay restitution in the amount of $2,380 directly to Rosa Delgado for unreimbursed therapy costs and lost wages, and $4,640 to East Harbor Community Pantry for damaged equipment and spoiled food. Money will not stand in for accountability here. It will simply cover what your choices cost other people. These payments are to come from your own earned income or assets in your own name. Then I said, I am also ordering a fine of $1,000 to the Newark Hunger Relief Fund. Your conduct did not only injure one person. It interrupted food distribution in a place where interruption has a human face. I want one part of this sentence to answer the wider harm, not just the nearest harm. Then I said, I am imposing 12 months of supervised probation with a suspended county jail term of 120 days if you refuse the terms of this order. I am doing that because accountability needs edges. If you walk away from the structure I am building, the wall is still there. You need to understand that. The center of the sentence was restorative. I said, you will complete 320 hours of service at East Harbor Community Pantry over the next 10 months, no fewer than 8 hours each week, including at least one 6 a.m. loading shift every Saturday and 2 Thursday distribution shifts each month. Not office work, not donor events, real work. The harm happened in a working place, and the person you hurt told me plainly what she needed. She needed you useful. Then I added the structured part. You will remain enrolled in at least 9 college credits each term or hold verified employment of at least 25 hours a week. You will complete 26 weeks of counseling focused on anger, grief, and family control. The evidence showed me a young woman with resources and very little inner frame. I am not sentencing you to drift. I am sentencing you to habits. And there was one more part, the most human part. Twice each month after your Thursday pantry shift, you will remain for the community meal for at least 30 minutes with no phone in your hand. You will sit, listen, learn names, carry trays if asked, and be part of a room that does not organize itself around you. I am requiring this because service without relation can become another kind of hiding. I gave her one condition for early completion. If by the end of 9 months you have paid full restitution from your own verified funds, completed at least 260 service hours, stayed in school or work without interruption, and received a positive joint report from probation and East Harbor, I will terminate probation 3 months early and vacate the suspended jail term. That was my way of placing a reachable mark in front of her. Not easy, reachable. Then I spoke to her as directly as I could. I said, you injured Rosa Delgado. You delayed food distribution to families who had done nothing to deserve your anger. You spoke to this court with contempt. All of that is real. But the charges do not contain the whole of you. I believe you can become useful in the exact place where you were careless. You do not get to erase what happened. What you do get is the chance to become a person who does not create that cost again. Lila, do not waste the mercy you have earned by finally telling the truth. Subscribe. I'm about to tell you what happened after the sentence, whether this person did what I believed they would do. Subscribe so you are here for that part. It is the part I care about most. What I noticed first after I finished was not Lila. It was Rosa. As the clerk gathered papers and people began to stand, Rosa opened her tote with her left hand, reached inside, and took out a folded pair of gray work gloves. She placed them on the corner of the defense table in front of Lila and said, Tuesday, 6 o'clock. Lila looked at the gloves, then at Rosa, and nodded once. That was all. I remained on the bench while the room emptied, signing the final order and initialing the probation page. Before I stood, I looked once more at the gloves on the table. Small things can hold a great deal. On that day, those gloves held more than many speeches I have heard from lawyers. The later fact I returned to most happened on June 12, 2026. It came to me through a routine compliance memo from East Harbor. At 5:54 a.m., before her shift had even started, Lila arrived in the rain because another volunteer had called out sick. A truck came early with 50-pound sacks of potatoes. The memo said she carried 6 of them before anyone got the pallet jack running. then spent the next 40 minutes hand-loading boxes beside a 71-year-old volunteer named Mr. Shu who refused to go home. That was the whole note. I did not need more. No appeal was filed. I will be honest with you about what that meant to me. It meant no one in that room was trying to turn a carefully built outcome into one more contest after the truth had already been spoken clearly. The sentence stood. So did the work. What this case taught me is simple. Compassion costs more attention than punishment does. It would have been easier to answer the money, the arrogance, the injury, and the insult to my courtroom with a short jail term and a clean speech about respect. People understand walls quickly. Doors take more work. This case required me to use every fact I had, not just the easiest ones. The thing it gave back to me was trust in my quieter judgment. If you have been where Lila was, let me tell you the one thing I look for from the bench when I am deciding whether someone is ready for something other than the maximum. I look for unforced honesty. I look for the sentence that makes you look worse before it makes you look better. I look for the work that starts before anyone promises you reward. If that is the path in front of you, start there. Tell the plain truth, then live in a way that gives the truth weight. And if you have been where Rosa Delgado was, with someone asking whether mercy is what you ought to want from a person who hurt you, I am not here to tell you what to choose. I would not do that. I can only tell you what I have witnessed. When victims chose mercy that matched the facts instead of denying them, they often seemed to leave with more ownership of the case, not less. The process had not spoken over them. It had listened. Months after the sentence, Rosa told probation officer Dana Keene something I still carry with me. She said, she learned names before she asked for forgiveness. That is not a slogan, it is better than one. It told me the work had landed where it needed to land, so I will leave you where I began. A letter from East Harbor Community Pantry. One sentence. She never signs out when the clock says she can. She signs out when the floor is clean. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you write in the comments, write like people who understand that justice and humanity are not opposites and never were.